there, folks. Welcome back and on to Chapter 5 in Civil Rights.
And here are the learning outcomes for the week. We'll define civil rights. We'll outline the historical experience of African Americans, the separate but equal doctrine, and the consequences of the civil rights movement. We'll compare the goals of the women's suffrage movement with the goals of modern feminism. We'll identify advances in GLBT rights. We'll outline levels of scrutiny used by the Supreme Court in civil rights cases and in recent rulings. And we'll evaluate whether and how affirmative action programs should be used to promote diversity in college admissions and hiring.
The 13th, 14th, and 15th Amendments are civil rights amendments. Now, these are actions that the government must do to protect individuals within the United States. The 13th Amendment ends slavery. The 14th Amendment, well, there's a lot to the 14th Amendment. It says that all people who are born in the United States are Americans, and that was meant to deal with the citizenship issue with regard to African Americans, former slaves. This creates an unusual situation in the United States to this day. Most countries in the world do not have birthright citizenship. So if you are born in Japan, for example, that doesn't make you Japanese. If your parents are Japanese citizens, that's what makes you Japanese. Whereas in the United States, as a child of immigrants in the United States, just being born in the United States makes you an American. So that's a key component of the 14th Amendment. It also begins to apply the Bill of Rights to the states, not all at once, but it begins that process. And it also uses the language all persons. It doesn't say all citizens. It says all persons are entitled to due process under the law, and all persons are entitled to equal protection under the law. Not all citizens, but all people. And so this was a big expansion, or intended to be a great expansion of equal protection under the law and civil rights. And the 15th Amendment says the right to vote shall not be denied because of race, color, or previous condition of servitude. Now, obviously, what is left out here is gender. And that was certainly not lost on the folks that drafted the 15th Amendment. And many activists in the feminist movement who had been very supportive of the abolitionists, the anti-slavery movement, felt thrown under the bus by not being included in 1870 and allowed the right to vote within the United States. And of course, it wasn't for another 50 years that women would be allowed to participate in elections nationwide. There were also a number of acts of Congress, new laws that were designed to put meat on these amendments and to provide details for these amendments on how the federal government was going to enforce the 13th, 14th, and 15th Amendments. Spend some time in the reading, getting an understanding for those laws. The 14th and 15th Amendments are effectively nullified. So are the civil rights laws that supported those amendments to the Constitution by several conservative Supreme Court rulings. In 1883, the Supreme Court rules that the 14th Amendment only prevents official discriminatory acts by states, not by private individuals, not by private organizations. And a political party would be considered a private organization, for example. And the Plessy v. Ferguson ruling lays out separate but equal, that it's okay if you segregate as long as there are equal accommodations. And this conservative court says that, races are not meant to interact. You can have a separate school as long as that school is equal. Of course, they got the separate part right. They never worried too much about the equal part. We could see that by school funding and educational outcomes and all that kind of stuff in the Jim Crow South and in segregated America. Also, with regard to the 15th Amendment, there were several legal barriers to voting, particularly in the American South, but throughout the United States. One of them being poll taxes, charging people to access the vote. This was finally outlawed by the Supreme Court in 1966. The application of literacy tests, having to demonstrate that you can read and write in order to participate in an election. These were not standardized. They were just simply put there to be an excuse to not allow somebody to vote. And in fact, in many cases, you would have African American school teachers who uh, uh, couldn't pass the literacy test that was being given to them by an illiterate person, an illiterate white person in the South. So these literacy tests were certainly not standardized in any way, and they were just meant to be an additional barrier. Um, Making an argument that political parties are private organizations and therefore they can exclude African Americans from the process. I kind of mentioned this a little bit earlier. And also, many states had a law referred to as the grandfather clause, which means that you had to demonstrate in order to access the vote, in order to go to the polls, you had to demonstrate that your grandfather had voted in elections. And of course, if your grandfather was a slave, then you could not demonstrate that. The Supreme Court precedent, separate but equal, it would stand for almost 60 years, and it's finally overruled in the Brown versus Board of Education ruling. The Supreme Court is now composed with much more liberal justices that had been appointed by FDR during his extremely long time in the presidency. And at this point, there is the votes to overturn the separate but equal doctrine. In addition to arguing that separate but equal inherently violates the 14th Amendment, um, the Supreme Court rules that desegregation needs to occur with all deliberate speed, and this is to be done through busing students across school districts, across cities, to achieve greater diversity. Um, and that was a very controversial decision that not only did separate but equal violate the Constitution, but that state and local government had to do something about that. That led to a great deal of conflict and controversy. In many cases, students are bused across town, and sometimes that was unpopular with white families, sometimes that was unpopular with black families, but they just didn't know a way that they could deal with the issue of the inherent problems with segregation without achieving some racial diversity. And as you probably know by looking at public schools across Minnesota and across the United States, this wasn't a particularly effective system, and we still see a great deal of segregation to this day, even though it is not segregation in law, but it is segregation based on where people live. So do make sure that you understand the concepts of de jure segregation and de facto segregation. De jure segregation being segregation in law, de facto segregation being segregation in fact. And so even if you get rid of the laws that enforce segregation, you still have segregation. You still have segregated communities. You have the history that went into that. You have the legacy that went into it. And you have the cultural conditions that maintain it. Also, we need to think about what led to the support for finally enforcing the civil rights amendments to the Constitution, 14th and 15th Amendment in particular. And this is, of course, the collection of leaders and individuals that formed the modern civil rights movement um, in the 1960s, and why it was effective. We often think about Dr. King's philosophy of nonviolence, and we see it as maybe from a purely moral perspective, but strategically it was highly effective because Southern leaders were arguing that African Americans are inherently unstable, that they're inherently violent, that they, if you invested in their schools, they would simply tear them down anyway. And so this strategy of peaceful protests and sit-ins and peacefully trying to integrate public facilities, it sort of turned that argument entirely on its head. And in fact, local authorities, by turning on fire hoses on peaceful demonstrators or sicking dogs on peaceful demonstrators throughout the South, um, as the media covered this and as these images made their way to the screens at night, it was quite clear that it was Southern authorities that looked inherently violent and it looked inherently unstable. And it was the protesters and it was the marchers that looked like the much more reasonable party. And this strategy borrowed heavily from the Indian independence movement under Mahatma Gandhi. So this is a very intentional strategy, and one not simply on the basis of moral basis of nonviolence. We have an image here of Martin Luther King's March on Washington, or his leadership there. As with the civil rights laws after the ratification of the 13th, 14th, and 15th Amendments after the Civil War, you need laws that are going to provide structure to the civil rights amendments in the Constitution. And that's where the Civil Rights Acts of the mid and late 1960s come into play. So the Civil Rights Act of 1964, it creates a system for voter registration that is organized by the federal government in the South to get people to register to vote and to overcome the terrorism that occurred that prevented people from participating in elections, that created equality in accessing public accommodations, including public schools, expand the power of the Federal Civil Rights Commission to enforce the law, withheld federal funds from programs administered in a discriminatory way, and established the right to equality of employment. Now, the Civil Rights Act of 1964 was obviously did not solve all the issues, so we've obviously needed to amend these laws over time. The Civil Rights Act of 1968 really deals with the issue of discrimination in housing. And the Voting Rights Act of 1965 puts the enforcement component into getting people registered to vote and eliminating any sort of discriminatory policies like voter registration tests that were meant to be barriers to African Americans voting in the South. So you have a massive federal voter registration drive. They are protecting African Americans both in terms of their access to getting registered to vote, but also participating in the vote. And this is a highly successful act, and into the modern period, we see African American voter turnout about the same as white or European descendant voter turnout in the United States, in large part because of this pretty robust law. All right, we'll pivot over to the women's suffrage movement. I talked a little bit about this before, that certainly many leaders in the women's suffrage movement were dismayed, to put it lightly, that they were not included in the 15th Amendment, and it wouldn't be until 1920 in the 19th Amendment till women nationwide are allowed the right to vote. Although there were many American states that did allow women the right to vote. I believe Wyoming was the first to do so. As the women's suffrage movement was closely related to the abolitionist movement, so was the modern women's movement a key component of the civil rights movement in the 1960s. Their specific argument was that for the need for an equal rights amendment to the Constitution that dealt specifically with the issue of gender and sex discrimination. This does get through both houses of Congress, but it fails to win the necessary states for ratification. As you know from your studies, in addition to 2/3 of both the House and the Senate, you also need 3/4 of all American states to ratify an amendment to the Constitution, and this was not ratified. Also included in the civil rights laws, the civil rights acts of the mid 60s and late 60s, was an attempt to deal with gender discrimination, which included both sexual harassment and wage discrimination for women. Certainly, the United States has come a long way. Certainly, Title VII of the Civil Rights Act was extremely helpful, yet we continue to see issues in both of these areas. In the contemporary period, this has not been a solved problem. I think most people would argue. Even today, women tend to earn about 80 cents on the dollar earned by men. And we see that when we compare similar professions. So, women versus men who are physicians or attorneys or accountants or, you name it. We continue to see that women make about 80 cents on the dollar. So in discussion this week, I want you to talk about some of the reasons why we continue to see that disparity. Is it purely discrimination? Or are there other forces that are at work? Affirmative action, or an effort to overcome the present effects of past discrimination. This is a very controversial area. What role does government have, could be at the state level or the federal level, in trying to undo past wrongs? And in doing so, does government violate the 14th Amendment Equal Protection Clause by treating people differently? In this case, providing a benefit because of your ethnic background. Affirmative action, as it is currently, as the programs are currently practiced, this is used most for educational admissions, admissions into colleges or university, or hiring in public institutions. Could be at the state level, could be at the city level, county, federal level, you named it. Now, people often today misunderstand what affirmative action is or isn't. The Supreme Court ruled long ago that use of quotas is unconstitutional. So we don't tend to see that. That is unlawful where it occurs. You can't say we're going to reserve 8% of these jobs, these government jobs, for people of, say, a Hispanic background. That has been determined to be unconstitutional by the Supreme Court. But what affirmative action programs can do is they can give extra consideration or support to traditionally disadvantaged groups. So for example, a university could say, hey, we serve a community that has a large African American population, and yet the African American population of our university is very low. We're going to spend extra money reaching out to these high schools that have a large African American population and provide incentives and additional support to get them to come to our college or university. And also, racial background can be part of somebody's autobiographical story when it comes to applying for colleges or a university or for a job. Now, it can't be the deciding factor. You cannot have two individuals, for example, of have dramatically different qualifications and select somebody because they meet sort of a racial background or profile that the institution is looking for. The Supreme Court, specifically in its ruling for the University of Michigan, determined that you could not use a point system. And as I mentioned before, quota systems have been deemed unconstitutional. So there can be some additional resources used to reach out to these groups to encourage applications and so forth. It could someone's racial background can be part of their story, part of their autobiographical component of their application, but it cannot be the determining factor on whether or not they'll be admitted to a university or hired for a job. I think it's safe to say the area of the most civil rights advancement over the last 20 or 30 years has been in the GLBT community. Laws targeting homosexual behavior now face much greater scrutiny by the courts. We've seen a massive sea change in terms of how society looks at homosexuality. We take a look back in the 1990s. It was Democrats who in many cases didn't support same-sex marriage or didn't even support civil unions. President Clinton signed into law Don't Ask, Don't Tell, which at the time was seen as a fairly liberal policy with regard to the military, which instructed people not to tell about their homosexuality, that they wouldn't be asked, but if it was discovered, they could still be punished for being gay. And that was reversed under President Obama. Likewise, the Defense of Marriage Act was signed into law by President Clinton. This basically said that federal benefits to same-sex couples would not be permitted with regard to, federal benefits or entitlements and stuff like that. The Supreme Court, led by conservative Justice John Roberts, has since said that there simply is no rational basis for denying people equality with regard to marriage. So this was something that was determined by a conservative Supreme Court justice who was in the majority, and it's an indication of how far the country has come with regard to gay rights and the rights of the GLBT community. And this also includes the rights of transgender individuals And those rights, again, would be hard to imagine 20 or 30 years ago. Okay, let's talk about civil rights and how they're protected by the courts. What are the standards for judicial review? Federal courts use three standards when engaging in a review of laws or executive actions, actions by government, to determine whether or not a law that could limit somebody's civil rights meets the standard of being constitutional. The most scrutiny the court uh, will direct toward a questionable law or action is strict scrutiny. Um, this would be related specifically to a right protected by the Bill of Rights or the 14th Amendment. And the court is going to look to see if there's a compelling government interest for this law, whether or not this law is narrowly tailored to meet that interest, and whether or not it's the least restrictive means of accomplishing this goal. So that would be the highest level of scrutiny. Um, Anytime a law is based on suspect classifications, it's going to get strict scrutiny. So, for example, a law that discriminates based on race, based on national origin, based on religion, the federal courts are going to take a very hard look at this and determine whether or not it meets this high standard. Intermediate scrutiny would be an area where there is a degree of a suspect classification. And this, in many cases, is gender. So, in some cases, it might make sense to have a law that is different for men or women. For example, there could be very good reasons to have a different paternity leave law relative to a maternity leave law because women are the ones actually having the child, having the baby. So, having some differences in how laws are created and carried out might make some sense in some situations for gender based classifications, but they're still going to draw greater scrutiny. Any law needs to pass a rational basis review, and that means that there's some reason that you can demonstrate for creating this law other than purely discrimination. So there needs to be some reason. It doesn't mean necessarily that the Supreme Court agrees that it's a good reason, but whatever government entity, whether it be the state level, whether it be the federal level, they need to be able to demonstrate that there is some rationality to this law. It was based on the rational basis review that same-sex marriage was determined to be lawful nationwide. That state bans on same sex marriage didn't meet the rational basis review. That is, there was no reason for denying marriage equality to same sex couples. And so, that was the basis. So, even to this day, any law that seeks to possibly discriminate against the GLBT community, they're not in that intermediate or strict scrutiny level. The court is looking so far as to whether or not there's any rational basis, although there are many within the GLBT community that would argue that a higher level of scrutiny is warranted by the courts. Immigration and the changing face of the American population is yet another critical contemporary civil rights issue. We've seen a lot of growth of immigration from Mexico, Central America, from Asia as well. And this is destabilizing for some parts of the American population. In 1950, this was a 90% white European descendant country. By 2050, it'll be a minority majority country where white European descendant people will be the largest minority, but other groups, largely groups of color, will outnumber them. So this has been, in certain parts of the country, a destabilizing force in American politics. Other parts of the country see greater diversity as a strength and something that has brought a great deal of dynamism to American cities and American communities. And so there's a great deal of partisan divide on the issue of immigration. Also, there's the feeling in some quarters that when immigrants come to the United States, they take opportunities that the population native-born population in the United States might have enjoyed. Now, when political scientists look at that, they see a much more complex issue because when immigrants come to the United States, they widen the economy. There are more opportunities. It's a larger, economy. The pie actually gets larger. So it's not quite so simple as zero sum. If somebody comes in, they take a job that would have gone to somebody else. But certain people, many people feel that way, and that creates some conflict between um, people who would like to limit immigration and those people who are seeking opportunities in the United States. We also have an issue with regard to unauthorized, illegal, undocumented immigration. People use different terms, and obviously they all have different shades of meaning. And the United States, too, as we discussed earlier, is a country that provides birthright citizenship. If you are born in the United States, that makes you an American. And so what that means is, people who are unauthorized to be in the United States may very well have a child who is an American citizen, or their spouse may be an American citizen. And this creates a great deal of difficulty. Some people simply suggest, well, people who are not authorized to be in the United States should be returned home. But again, like with so many political questions, that's an oversimplification. Are you willing to break up families? So what processes should you put in place to create a path um, to residency or citizenship? These are the big political debates that we're having on these issues. All right, let's summarize. The Civil Rights Act of 1964 bans discrimination in employment, public accommodations based on race, color, religion, gender, national origin. Affirmative action programs created to reverse historical injustices remain very controversial, and some argue they lead to reverse discrimination. America's racial and ethnic demographics are changing rapidly, and as I mentioned just a few minutes ago, by 2050, there will be no ethnic majority in the United States. It will be a minority majority country. And there are certainly elements of the United States electorate that finds that to be destabilizing. The Civil Rights Act of 1964 also prohibits workplace gender discrimination and outlaws sexual harassment, but we know these remain issues and we still see a pronounced wage disparity between men and women in similar jobs. Um, Even though the federal government is not applying strict or intermediate scrutiny for laws that prohibit discrimination based on sexual orientation, we are seeing state and local governments develop laws that prohibit um, discrimination. So there's movement there on the state and local level, and also the Supreme Court has been willing to say that efforts to deny equality to same-sex couples do not meet the rational basis review, that lowest standard of review when it comes to whether or not a law is constitutional or not. And lastly, discussion questions for the week. Again, one substantial original post where you're drawing on class readings and going in depth on one of these questions. Also, at least two responses to the on-topic posts of your classmates. You do all that, you'll be looking at a perfect discussion grade for the week. As always, please reach out to me with any questions or concerns and have a fantastic week.